Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. In the Barry Morphew case, the judges tied the prosecution's hands. Could the prosecution really lose this case? It feels like Barry's winning so far, doesn't it? Well, is he? A YouTuber that is also a defense lawyer in Colorado seems to think so, simply based on the title of one of his last videos. According to an article in KUSA.com, quote, a judge in Fremont County denied a motion Thursday to admit prior acts of alleged DV in Barry Morphew's murder trial, end quote. On the face of it, it seems really unfair not to allow allegations, yes, even allegations, in a scenario where a wife has disappeared. And by the way, Suzanne's still gone. Nothing of her has been found, not even her phone, and the husband has been fingered as the prime suspect. Let me simplify this at the risk of being reductionist. Imagine you're being bullied at school and you want to do something about it. You go to the principal's office, you start to talk about prior incidents, and there are many, and the principal abruptly interjects and he says, hey, I refuse to listen to any allegations or hearsay. And then the principal adds, he says, the information is relevant and raises great suspicion, but only if I use it in a prohibited purpose. And those are actually the words used by Judge Lama in the Barry Morphew case. The information is relevant and raises great suspicion, but only if I use it in a prohibited purpose. What do you think he means by that? Before we get to that, if you haven't subscribed to the channel, please do. Like, share, leave a comment, and let's get started. The reality is the law is right and reasonable on this aspect, even if it doesn't always seem fair. The class of evidence that the judge is referring to is 404B evidence, and that is evidence of prior bad acts that the prosecution can introduce in their case in chief. Under Federal Rule of Evidence, commonly abbreviated to FRE 404B, the prosecution is able to introduce evidence of defendants' prior bad acts that are not charged in the instant criminal case. Now, where 404B evidence is at stake, a few considerations need to be met. One is relevance, another is proper purpose. I think the third is applicable here, and that is its probative value is substantially outweighed by its possible prejudice. Remember, Barry Morphew is on trial for murder, not for DV, not for some lesser charge. The judge in this instance has found the 404B evidence to be prejudicial, and since the law gives a presumption of innocence, that presumption needs to be protected. In terms of criminal psychology, we often see recidivism playing out in an ever-widening pattern. Lies, deceit, slights, etc. pile up and escalate, eventually culminating in the act itself. In a scenario where there really is DV, but you're not allowed to talk about the precipitating events, it's going to be tough to field your case. Imagine in the Chris Watts case if he'd gotten a lawyer and the prosecution weren't allowed to, let's say, mention Nicole Kessinger. Imagine if, for whatever reason, there were no texts to rely on, and Watts hadn't confessed and the remains of his wife and child had simply never been found. How would you begin to prosecute such a case, especially with your motive and intent in tatters? I think this was a major hurdle that manifested in the O.J. Simpson case. Ironically, the victim in that case, Nicole Brown Simpson, had documented DV and even placed color photographs of her injuries in a safety deposit box. But in the absence of Nicole herself to take the court through the images, the accused was able to spin the story, and he did. He said those weren't actually bruises, but stage makeup. Despite the police losing count of the number of times Nicole had called the police to report TV, the jury evidently believed the accused. How would you begin to prosecute such a case, especially with your motive and intent in tatters? In the high-profile Shreen Dewani case that played out in South Africa, in Cape Town, South Africa. The judge in that case decided that questions regarding the sexuality of the husband of the murdered spouse, quote unquote, didn't matter. And this is a quote from the UK Telegraph, quote, "The state is expected to say he wanted her dead because he was gay and wanted to get out of his marriage. Mrs. Roberts said he trawled through the hard drive of Mr. Dewani's laptop looking for references to keywords that might be relevant to the case, including gay, fetish, rubber and water sports, as well as places in South Africa and the names of other accused of involvement in Mrs. Dewani's murder." When Mr. Mop asked the witness to read the emails, the judge interjected. She said, "Why is his sexuality relevant?" And this is what she asked the prosecutor. She pointed out that the emails were sent over a year before his wife was killed. Mr. Mop countered that they provide the context and give an indication of his motive in the alleged murder. He was conflicted about whether to get married or whether to come out, he said. And so the judge said, and what does that prove? Motive to kill. In other words, the judge was asking, is the sexual orientation of the spouse, is that really going to prove motive? And Mr. Mop responded, obviously not motive to kill, but the man expresses a conflict within himself. The judge then fired back, but I'm sure that's true for many, many people, including those sitting in this court. Then Francois van Zyl, Mr. Dewani's barrister, said reading the emails would be highly prejudicial to his client, who has already admitted he was bisexual and had relationships with women and men, including prostitutes. The article goes on to say that Mr. Mop said the peculiar interests of the defendant would form part of their argument of his motive. The accused sexuality is an issue that you cannot hide away from in this matter, he said. The prosecutor added that in his profile on the dating website Gaydar, Mr. Dewani described himself as a single gay man, not bisexual. But it's not in dispute. This is what the judge said. It's not in dispute if he's bisexual or he's gay. It doesn't matter. And anyway, the prosecutor, Mr. Mop, said, a bisexual person is attracted to both sexes, a gay person is attracted to one. The bottom line in that particular case was that the judge felt that the sexuality of the accused was irrelevant, it didn't matter, and was sort of prejudicial. And so all of that evidence was thrown out. And was that correct? And so, anyway, according to Wikipedia, on 24 November 2014, after the close of the prosecution's case, Dewani's counsel argued for the case to be dismissed. And about 2 weeks later, on 8 December, the application for dismissal was granted by the Honourable Judge Traverso. So you kind of had the situation where the prosecution are trying to field a case, and then the argument is successfully made that certain arguments are prejudicial. You throw that out, you throw out all that kind of information, then what are you left with? And so in this particular case, the lawyers for Dewani asked for a dismissal, and they were granted it. We've seen the same thing in the Barry Morphew case. His counsel asking for the charges either to be dismissed or to be lessened. In the Dewani case, he was acquitted and exonerated of all involvement with the crimes. In her judgment, Traverso ruled that there was no credible evidence linking Shreen Dewani to the crime. And so that is the question in the Barry Morphew case. Is there credible evidence that actually links Barry Morphew to the crime, the alleged crime? Now, in my opinion, in the Dewani case, the judge erred in disallowing that evidence because of a particular assessment on its probative value. In other words, the evidence wasn't hearsay and it wasn't in dispute. In the Morphew case, it helps the accused that personal items belonging to Suzanne, such as her phone and her diary, have also disappeared. And I think one's got to bear that in mind, where you have certain informational catalogues disappearing. Are you supposed to say, well, we don't know, and so we can't speculate in that area. So we just throw that out. I think it also helps the accused, Barry Morphew, that his two daughters openly support him, and if they elect to testify in support of him, it's difficult to imagine any reinforcement of the disputed DV narrative. The DV narrative is important as a potential precursor to something that is possibly worse than that, if you follow my drift. One would imagine if there was DV that the daughters would know. I'm not sure that's necessarily true, but what is indisputable is that the Morphew daughters had an inside track into the emotional Richter scale of the household. They may have not known everything, but they certainly would have known some of what was going on. But this also raises another interesting point. If one of them, say, chose to refer to DV incidents and the other didn't, could that evidence be ruled as hearsay and prejudicial as well? In other words, if one daughter elected to testify in a certain direction, could you then argue, oh, well, that is hearsay and prejudicial? It does seem in cases like this where a wife disappears and evidence is swept away, deleted, covered over, and in the continued absence of the victim, the prime suspect gets to control the narrative, where the victim loses all of her rights while the prime suspect is afforded various protections. It seems to not only favor the accused, but one can see how other potential criminals looking in might go, hey, I might get away with this. I think one of the issues in terms of the probative value is, in terms of the speculations around DV, the question was, well, can you be specific? When did it happen? What happened specifically, etc.? The evidence needs to be specific, not kind of just a broad statement. So let me ask you, how would you begin to prosecute such a case, especially with your motive and intent in tatters? Well, it's not impossible, and I would propose almost playing the devil's advocate in this case. If you're trying so hard to bring Suzanne Morphew to life and to prove certain things, there's another way of doing it. Instead, you put the shoe on the other foot and you say, Suzanne's not here. Barry, you're married to Suzanne. Where is she? Don't you know? Why don't you know? And so, as we saw in the Frazee case, even without a body, the worst aspect to the prosecution's case can also be the best evidence the prosecution have. The absence of evidence is also evidence. The absence of Suzanne is also evidence. If the defense case is, well, what is the defense case? But if it's that Suzanne is somewhere out there sipping mojitos on a beach in Guatemala or Uruguay and living happily ever after, it's just unknown where she is, but she's somewhere out there. Is that really more likely than that she isn't? If one of your family members was on trial for your murder and you were alive and well, sort of hanging out somewhere, would you really not make your presence known? Most people would. So although the prosecution's hands are tied, what they do have are a few basic inviolable facts, including, number one, Suzanne Morphew has been missing without a trace for almost 2 years, since May 10, 2020, and she is very likely dead. 2. The last person to see her alive was her husband, the suspect, and this is common cause. 3. The circumstances of the bicycle accident appeared unconvincing to law enforcement, suggesting a quote-unquote staged event. Even the bicycle itself appeared undamaged, implying a life-threatening injury from its rider was unlikely. No blood, skid marks, or tracks were found around the bicycle. No blood was found associated with the helmet either. Number 4, the behavior of the accused on the day of the incident, a Sunday, wasn't a little out of the ordinary. It was highly unusual. I would say something like shooting 85 chipmunks is highly unusual behavior for any person, even a hunter. Number 5, do the circumstances of the marriage provide useful, important, meaningful, and relevant context to the alleged disappearance? Does the fact that Suzanne herself was using a spy pen to record her husband's activity suggest heightened levels of honesty or dishonesty, heightened levels of trust or distrust, between husband and wife. It will be up to the prosecution to field this context in the proper way and in a compelling narrative. I think the most compelling narrative will win this case. They may have no trouble proving Suzanne was having an affair and how this led to increased instability and strong emotions within the marriage, and that may be sufficient. Will there be any evidence of infidelity from the accused? I'm not sure that's important to prove. Rather, I think it's important to show that that is what Suzanne believed and or experienced. Does that make sense? Regardless, the Morphew marriage was in serious trouble. Even one of their daughters was recommending divorce, and it was within these fraught circumstances, as well as a scenario where the accused owed the deceased a significant sum of money, and the deceased indicated her intention to imminently leave the relationship, which would mean those debts would mature, and in turn the accused faced instant limits to his lifestyle and access to resources. And within these escalating circumstances, Suzanne Morphew disappeared. One must also necessarily ask who stood to benefit most from Suzanne's disappearance at the time she disappeared. If it appears the defense in this case has the upper hand, I'm not sure that's true. It's certainly not as cut and dried as some seem to think it is. It is a legal illusion given the circumstances in this case. Well, that's my view anyway. Thank you for listening, and I'll see you guys next time.